Steve, you know there's two different kinds of disability claims. There's the ERISA disability claim, which is an employer-provided product, and then there's the private disability claim that someone buys on their own. Let's first talk about the ERISA claim. If a person gets denied, what are their options?
Well, number one, their option really isn't an option, it's a duty. The law is going to require that you file an administrative appeal. So after a filing of denial, your next step before you can bring a lawsuit is to go through that appeal process.
Okay. And do you have to file one appeal, two appeals? How does that work?
It's a mandatory one appeal under the law. Except other companies can require more. For instance, Lincoln requires 2 levels of mandatory appeal. Some companies will give you a voluntary appeal, such as Prudential and Cigna, and some companies like Unum, Hartford, and Aetna, it's only one appeal with no option for a voluntary.
All right, and real important that in those appeals that they have to give you 180 days to do the appeal, but that's a strict 180 days
Correct.
that you must get the appeal in. However, if you're someone who's sitting there saying, wow, I only have 20 days left, it is possible to ask for an extension. You should still call us under any circumstances, but doesn't mean they're going to give you the extension. There's still things we can do. We prefer not to be in that scenario with a very limited period of time, but I've taken them the day before, I've taken them a couple days after, asked for extensions, and just tried to get together whatever we could so we could reserve the rights for an appeal. Because if you don't do the appeal, then you can't file a lawsuit.
Correct.
And that's deadly. Too many people call us and go, well, the 180 days ran, I never got permission for an extension, and we unfortunately have to tell them, well, now you can't file a lawsuit unless you get permission from them to do so. So obviously we have lots of other videos talking about ERISA appeals and how important those are, but the option is if you get denied is file an appeal, and then if you lose that, a lawsuit. What about for the private claim, the person who gets denied? What are they required to do, or what can they do?
Well, I would say for 90+% of them, if there is a denial, you would have rights to immediate legal action. In some instances, for instance, the Great West policy, which is technically a private policy to dentists, that policy does require a mandatory level of appeal before you can file a lawsuit. But barring that, the vast majority of your private policies, you would have the ability to bring some type of legal action, although most of those carriers will give you the ability to submit an appeal. So you do have more options available to you.
Right. You know, it's interesting. If they put in there that in the private policies that you had to do an appeal, then that would be binding, because it would be like a condition precedent to coverage saying you have to do it. I rarely ever see it. You mentioned one where it's in there, but it's rarely in there. But the other thing that we've had success in doing on the private claims is kind of doing our own appeal or reaching out to the company through many of our contacts and trying to avoid the long extended process of litigation and trying to get a case resolved. And that's something unique that our firm's able to do because we've handled so many claims for so many years with the disability companies. So be highly advantageous for you to give us a call and talk about that option, because going through litigation, while we try to make it a painless process for the claimant, it's certainly something that can last anywhere from 6 months to 2 years.
And it's very intrusive, you know, especially on the private policies and, you know, everything that can happen during the course of the litigation. It can become very intrusive into one's life.
Right, and then even when we do get into litigation, whether it's on the ERISA side or on the private side, more often than not, we're able to cut the litigation, keep it down to a very short period of time, and reach a lump sum global type settlement for the claimant, in which you're paid one-time payment of money which buys out your policy for the past and the future. And a lot of claimants like that because they're done with the company. They don't have to worry about them breathing down the neck for the rest of their life or however long the claim is. And it shortens the whole process. And the reason that our law firm's able to get that, again, is because of the relationships of fighting them so many times that they're like, you know what, we're not going to pay our lawyer, their lawyer, hundreds of thousands of dollars to defend when we know you're going to get to point A or point B. So let's try to sit down early and resolve this case. I mean, what's your take on trying to get it, like what's a mediation or an early resolution?
You know, I think in a lot of situations too, and it's a disability claim, there's denial, there's no income coming in. It also benefits the clients, and the clients really are looking for some way to try to resolve the matter. And if you can effectively do that, like you said, it gives the client peace of mind. Obviously, in resolutions, it's always a compromise. It's not an ideal situation. Anytime you end up in a type of lawsuit, it's not an ideal situation, but at least brings it to a quicker resolution, so a person can kind of, you know, put that chapter behind them and take the steps forward beyond it.
So if your claim has been denied or you're worried that your claim's going to get denied, give us a call, fill out our free consultation form on our website. We always offer a free consultation, and we look forward to the opportunity to speak with you.